Apparently lost, and
In transit.
and something else is still in transit. So
Okay.
I don't know what those things are yet. Just going to maintain the suspense.
Yeah.
But our power went out again yesterday.
You said, I meant to ask you that.
It
When did
went
come
out.
back on?
It came back on around 3, and it went back off at 3:30, and didn't come back on until almost 11 o'clock. So I didn't get to bed until after. It was probably close to midnight.
Well, how did you have all those yummy sides with your dinner?
We got the generator.
Oh, you had the generator. Okay, yeah. Because I was gonna say, I was like, I didn't think you guys had a little bit of mac and cheese or something with it.
So, Mr. Asmunsen, which case are you on?
Your Honor, I'm here on the Roehrig case. Roehrig
okay.
versus the Michigan Department of Corrections.
I thought since you got here first, I should give you the privilege of going first. So let me see who else is here on that one. Let's see. Looks like plaintiff's attorney. Who do you represent?
I represent the defendant, the Michigan Department of Corrections.
All right,
Well, I
and
guess
you're
all
not
the defendants,
you're not expecting any other attorney on behalf of defendants today.
No. I
All
only
right,
expect Jonathan Marco.
And I don't see Mr. Marco. Oh, here he is. He just logged in. All right. Okay, Shannon put us on the record.
Okay.
This is a matter of Roehrig versus Department of Corrections et al. Counsel, state your appearances, please.
Good morning, Your Honor. John Marco, and I apologize for being late. I was having some trouble with getting into the Zoom room.
Good morning, Your Honor. Kendall Asbenson on behalf of the defendants.
Benson?
Asbenson.
Asbenson. Yep.
Asbenson.
Thank you.
Okay, so we've got a motion to compel and a response that perhaps could have been filed as a motion for a protective order, but the issue is whether or not the court should be compelling the director of the Department of Corrections to give testimony at a deposition.
Yes, Your Honor.
All right, since the normal course would be anyone who's a party to a case can be deposed, I think the burden is definitely on the defendant to convince me that this person shouldn't be compelled. So even though it's plaintiff's motion, I think I want to hear from defendant's attorney first.
Of course, Your Honor. Your Honor, in this case, Director Washington, while she is a defendant, she is the sole head of a principal constitutional department. And so the case law in Michigan has firmly established that you may not depose the sole head of a principal constitutional department unless you have a compelling need. And the cases of Fitzpatrick and Hammond have established what that compelling need is. You first must demonstrate that you cannot get the information from a lesser ranking officer. And second, you must demonstrate, you must alternatively demonstrate that you cannot get that information through some other form of discovery, be that written deposition or be that interrogatories. And this, Your Honor, jives with the Michigan rules on discovery, which were modified earlier last year. And the scope of discovery under the modified rules states specifically, and I'll read it here in 2.302, subsection B1, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claims or defense and proportional to the needs of the case, taking into account all pertinent factors, including whether the burden or expense of the proposed discovery outweighs its likely benefit. And Your Honor, in this case, the reason that Michigan, since for decades, has had this apex rule with regard to deposing senior administration officials is because the burden of producing such an official outweighs any of its likely benefit. This information, we're not saying that Mr. Marco can't discover this information. He needs to take the deposition of Kathy Warner before he takes the deposition of Heidi Washington. And he didn't even notice that deposition until after this motion was pending. Kathy Warner can testify from everything that I read in Mr. Marco's motion. Kathy Warner is competent to testify regarding that information. She should be deposed.
Well, let me stop you for a minute. I note that Director Washington was sued in her individual capacity, not in a representative capacity. She's an actual party, excuse me, to this proceeding. I would anticipate that she would be testifying in her own defense if indeed the case against her goes to trial, would she not?
Your Honor, I can't say one way or the other. There, at this point, from what I have seen, there would be no, what I have seen right now, I don't see a need for her to testify. And that's part of the problem. This motion is premature, Your Honor. Mr. Marco hasn't established a need to take this particular deposition. The capacity is relevant.
So I'm sorry, I've got a little frog in my throat this morning. So I didn't look at the complaint. I only looked at the caption, and it says she's sued in her individual capacity. So if she's sued in her individual capacity, I have to assume that there's an allegation in the complaint that accuses her specifically of engaging in an act that would create liability to her personally.
I have
is
not.
Is that a wrong assumption?
Your Honor, this is a run-of-the-mill employment case.
Well, in a run-of-the-mill employment case, you don't normally sue the director of the department, except maybe in a representative capacity. For her to be sued in her individual capacity, there must be some allegation there that she did something in her individual capacity that would give rise to personal liability. So let me stop you for a minute, and I want to hear from Mr. Marco. What is it you're claiming that your plaintiffs are claiming in their complaint that the director did in her individual capacity?
Sure, Your Honor. Ms. Washington is an individual defendant, not just because she's the head of the Department of Corrections, but because she had direct involvement in this case, including in the handling of complaints made by the plaintiff and in the discipline of the plaintiff. The plaintiff was fired, and then that was ultimately found to be a wrongful termination by an arbitrator. If this court recalls, so Judge, just so you understand what this case is about.
Don't assume that I recall anything, Mr. Marco.
So Judge, this case is an employment discrimination case, but it's not really run of the mill. It's pretty complicated, but it boils down to allegations that the plaintiffs reported illegal activity to the director of Heidi Washington as well as others. Specifically, Mr. Warrig reported illegal drug smuggling of another employee who was smuggling drugs into prisoners. He reported this to a state senator, and he reported it to his superiors. Mr. Warrig also made several complaints directly to Heidi Washington, and I outlined those in my brief, but specifically on October 21st, 2016, he emailed defendant Washington stating, I've repeatedly asked to be allowed to. I'm sorry.
So I saw all of that. I saw there were communications directly to the director. What I'm asking is, what is alleged that the director did or did not do to give rise to individual liability on the behalf of the director?
Sure. The allegation, and this is supported by evidence now. It was originally just an allegation, but now it's supported, is that the director retaliated against the plaintiffs for complaints in violation of the Elliott Larson Civil Rights Act. To sum it up, she terminated them. She had direct involvement in their termination because they complained about illegal practices and about discrimination. And this isn't just a hypothesis. I mean, this is supported. If you recall, Mr. S. Benson tried to prevent emails from being turned over. Once we got those emails and memorandum, we have the director, Washington, directing people to take action against the plaintiffs in response to the complaints that were made specifically by Mr. Rohrig. And under the Elizabeth versus Ford, which is a Michigan Supreme Court case, and I know, Judge, that you know employment law very well and that you used to practice in that area, the Elliott Larson Civil Rights Act provides for individual liability of the person who committed the wrong. And so in this case, there's direct evidence, and it's alleged in the complaint that Heidi Washington retaliated against the plaintiffs, got them fired, essentially, for their protected civil rights activity. We have that in the forms of the emails that I outlined to you. We also, in one of the most blockbuster depositions I've ever taken, if you read these memos that I attached, we have the head of internal affairs who was responsible for investigating both plaintiffs in this case that ultimately led to their termination, complaining directly to Heidi Washington and stating that I'm being told to alter my investigation findings in order to find guilty where there's not guilty and not guilty where there's guilty. And she's an individual defendant in this case. I mean, how we have to be able to prove our claims. And you just heard Mr. S. Benson say, oh, we don't even think we're going to need to call her at this time. So they're going to try to prevent me from proving the elements of my case. And the apex deposition rule, as this court knows, is to prevent harassment of directors and of CEOs where they really don't have direct involvement in the case. So, if this was just about, some employee being called a racist term or some hostile work environment at a local facility level, they would have a really good argument on why we shouldn't have to depose the director. But in this case, we have direct evidence and direct allegations against her as an individual defendant that she directly participated in the termination, in the investigations, and she was the recipient of the complaints that give rise to this whole case. I mean, this whole case is based on the complaints that were made to her. There's no way that any court envisioned the apex deposition rule to apply in a case like this, which would essentially prevent plaintiffs from bringing a claim against the highest person. If you accept defendant's argument, we could never sue Heidi Washington, no matter what she did or how bad it was, because we wouldn't be able to depose her to get that information. So, Judge, for those reasons, this is a special case, and Fitzgerald was decided, 40 years ago. It's a lot less burdensome now when we have Zoom. We'll have a limited deposition. We'll be able to do it very quickly. She'll be able to do it from the convenience of her house, and we'll do it whenever she wants. I mean, this is not an attempt to harass anyone.
Is it your contention that the director actually directed that retaliatory acts be taken against these plaintiffs?
Yes, along with Kathy Warner.
And
yet because Judge, here's excuse me,
Hold
Mr.
on,
Asmussen.
Mr. Asmussen. I'll give you a chance.
Judge, just so you understand how the discipline works, because corrections is a vast beast, but the investigation of the plaintiffs was done by Stephen Marshke, who's the head of internal affairs. He signed off on the investigation, but the discipline is imposed by Heidi Washington's office, by a woman named Kathy Warner. Kathy Warner is the one who also has to sign off on this discipline. And she's out of Washington's office. She's out of Washington's office. She works directly for Heidi Washington. So this isn't some tenuous relationship. So in this case, the complaints were made directly to Heidi Washington. And then we have emails from Washington to Kathy Warner, who's the woman who's signing off on discipline of the plaintiffs, stating, we need to deal with this. And so she's directly involved. She's directly involved in the.
Wait a minute. An email from her saying we need to deal with this and directing her subordinate to do an investigation and come to a conclusion as to what should happen is not the same thing as an email saying, I want these people fired. You need to follow through on this. So which is it?
Well, Judge, the complaint alleges that she did directly participate and say that and retaliate against the plaintiffs. But if you look at like Exhibit 1, for example, this is what happened. Okay, so Exhibit 1 is an email. This is just one little example. So Mr. Warwick complains directly to Heidi Washington and says, I'm being retaliated against. I've spoken up and now I've reported things and now I'm being retaliated against by internal affairs. Heidi Washington, then we have emails of her taking that complaint and telling Kathy Warner, we need to talk about this on the phone. Okay. She says, my questions pertaining to the investigator, call me on the phone. So under Mr. S. Benson's theory, I can't depose an individual defendant in this case who we've made direct allegations against, who has direct liability about a phone call that she had. Why did you send this email? What did you do when you received this email? There's no one else I can ask about that. There's no one else that I can, who has the best knowledge of that. And if you look at the case law interpreting this, courts have never applied the apex deposition rule in a case where they're an individual defendant who has individual involvement in the case. So if you look at the case, the cases that I cited, it says that where it cannot be used to shield a high-ranking official from discovery when that high-ranking individual has personal knowledge that is relevant to the issues in the case. Personal knowledge. We've not only alleged that she has personal knowledge, we've proved it. I've showed you direct emails. I don't know what else we could do unless we had a smoking gun that said, fire these guys for complaining. But we know that never happens in employment discrimination cases. At least not in the ones I have. Everything, no one documents that they're violating civil rights laws intentionally. So we needed to ask her about these things. And there's no case that they cite that would shield an individual defendant from these types of claims. If Fitzpatrick, they said that you can't just schedule the deposition of a high-ranking official in bad faith to harass the opposing party. And so if my run-of-the-mill employment case, if I just started deposing the director every time to try to harass them in bad faith, yeah, they would have a really good argument, Judge, but not when I've showed you emails, direct emails from the plaintiff to the individual defendant, Heidi Washington, about the core claims in this case. You'd be preventing us from litigating this case. If Mr. S. Benson stipulates that Heidi Washington has liability and he will not file a motion to dismiss her, then I will agree not to depose her. But in the absence of a stipulation on liability, how in the world can I do that, Judge? How? All
right, let me hear from Mr. Asmundson.
First of all, Your Honor, virtually every single case that Mr. Marcos cites in his brief is a foreign case. It's not a Michigan case. I've outlined already the rules established for the Apex rule in Michigan, in Fitzpatrick, and even in the 2000s with Hammond. The memos, Mr. Marco misrepresents what the memos actually says. He says that Mr. Marshke claims that there were changes from guilty to not guilty or not guilty to guilty. No, it was from sufficient evidence, or excuse me, insufficient evidence to no evidence. It was not guilty to more not guilty. It's not like there was a change in guilt. First of all, though, I guess what I should have started with is all of this communication to Director Washington. If Mr. Marco had any evidence that Director Washington actually made some kind of relevant decision, he would bring it before you. All he has are emails from his client complaining about his conduct to Director Washington. And Mr. Marco brings this particular motion frequently. This is not infrequent in his employment cases. And it hasn't been granted yet. But Kathy Warner can testify about what Director Washington did to her. Kathy Warner can testify what they talked about on the phone. He hasn't even tried to depose her yet. Her deposition is not even set till the end of this month. This motion is premature. He needs to talk to Kathy Warner before he talks to the director. I'm not saying absolutely in no case can you ever depose the director. I'm saying this motion is premature. He needs to depose Kathy Warner, and then if he cannot obtain whatever else he needs from Director Washington through the 6 interrogatories that he has left, which she has already answered 19 of, by the way, or through written depositions, the director is dealing with a pandemic here, which is rather prevalent in the facilities. This is an undue burden under the court rules to depose Director Washington at this time. I know we represent the director frequently, and I know of one case in which a trial court ordered her deposition and we took it up and had it reversed on an interlocutory appeal like that. This is not something that happens. There is no allegation that Director Washington personally told, or excuse me, there's no evidence that Director Washington actually directed any of her subordinates to fire Mr. Roehrig or Ms. McCabe. The allegation that just because someone works for Heidi Washington, therefore she's guilty, it is a stretch, Your Honor. Kathy Warner is the head of internal affairs, and the individual who made the decision in these cases was Jennifer Nancy. Your Honor, Mr. Marco needs to be able to actually show that Director Washington had some kind of, did something in this case other than tell her subordinate, deal with this problem, that being the problems that were raised by Mr. Roehrig, or actually played some actual role in the termination. There's no evidence that she played some actual role in the termination. Now, maybe John can prove that at some point. Maybe he can actually bring evidence. But I think he called it his just one little example of Director Washington influencing this case. That was the biggest example he had. And all it is an email his client is sending to the director, and the director wants Kathy Warner to make sure that there's no problems. Now, Kathy Warner is competent to testify about what happened on that phone call. Mr. Marco needs to talk to Kathy Warner before he can get to the director.
Judge, may I respond?
Gentlemen, here's what I'm going to do. I'm going to direct you, Mr. Marco, to take the deposition of Kathy Warner first. In all likelihood, I'm probably going to give you the ability to depose the director as well. But I do agree with Mr. Asmunsen. The director has a whole lot of stuff on her plate right now. And before I'm going to allow you to depose her, you're going to have to demonstrate that as a result of the person who apparently, if she did direct that adverse action take place, that's the person who she would have directed. And that doesn't mean that just because this particular witness denies any of that, that means I wouldn't let you depose the director. But I want you to take that step first. And then if the two of you still have a dispute over this, once that deposition is done, you can renotice your motion. And I'm likely to be very sympathetic to it.
I understand, Judge. So should I enter an order stating the matter is taken under advisement? Plaintiff shall take the deposition of Kathy Warner as scheduled and then renotice this if necessary, or something like that?
Well, I'm not really taking it under advisement. When I do that, it starts a clock ticking, and I don't want it to show on my report that I've had a matter under advisement for 2 months. So the court is denying the motion at this time without prejudice, with the right to renotice the motion at a future date if necessary.
Okay, thank you, Judge.
Thank you, Your Honor.
All right. Thank you, gentlemen. Have a good day.
You too.
Okay, looks like we've got audio connections with everyone. Excuse me, this is Exclusive Brands versus Battery. Counsel, could each of you please state your appearance for the record?
Jason Yurt and David Warren on behalf of the plaintiff. Happy New Year, Judge. Good to see you. You're looking well rested and happy.
Happy New Year to you. Thank you.
Good morning, Your Honor. Justin Baghdadi on behalf of Battery Company. And my client is also on the phone. It looks like he might be still connecting to the audio, but that's Andrew Goldstein. He's the representative of Battery Company.
Bagdady.
Thank you.
Okay, and I see Mr. Goldstein initially didn't have an audio connection, but he appears to have one now. So I see competing discovery motions with a lot of information being requested by both sides. I would describe as a fairly contentious case, just given the number of times I've seen you gentlemen in my courtroom. I will tell you frankly, my inclination is to order you pursuant to, and give me just a second here. I had hoped to have my court rules open before I called you. Well, wonderful. Oh, okay, here we go.
Wait.
I got it. I got it.
I was looking forward to. I was looking forward to.
MCR 2.411H, mediation of discovery disputes. The parties may stipulate or the court may order the mediation of discovery disputes unless prohibited by MCR 3216C3, which I don't believe applies here. Why shouldn't I do that? And before you answer that, has there been any attempt to facilitate an overall resolution of this matter?
David Warren, yes, we have been to facilitation once. We didn't settle the case. I can't say that it wasn't necessarily productive, but it did not result in a settlement.
All right. So, and then the question I asked previous, why shouldn't I do that?
Well, Your Honor, it's funny. In the last discussion that I had with Mr. Baghdadi day before yesterday, or maybe the day before yesterday, we had actually discussed that as a possibility. We had not come to any particular conclusion.
So I'll tell you, Your Honor, I mean, you are certainly right that there's a number of discovery issues to be sorted through here. And if you're inclined to have them resolved that way, then I'm not going to get in your way, or tell you shouldn't do that. My only concern really is timing, in that we've got discovery cutoff coming pretty soon. We've got a trial date coming not too far off. And, I don't want to be pushing those deadlines. I'd like to stick to those deadlines and get ready for a trial in June. So as long as we can do it in relatively short order and get somebody in place and up to speed and in time to resolve all these things, then that's fine. But the timing is my only concern with it.
Judge, we're the way it's boiled down now, we don't have enough documents. For example, we don't have a single communication, email communication or text message from the defendant to any third party. We know those exist because CLDD produced discovery to us with emails to Mr. Goldstein, and that's just one third party. So we have 0 emails, 0 text messages that were produced in discovery. I'm great with having a discovery master. I think it's a great idea. I think it would take up way too much of your precious time to go through this request, and having a mediator is the practical solution. Waiting through each request. I mean, you don't have an hour or two to. You may not, but it's going to take considerable time to do it. We're going to need more. If the court is inclined to grant or consider, in all practicality, this case has been going on during the pandemic. I know my client has been ravaged, unfortunately, with COVID-19 throughout its facility and its principals as well. Our office has as well, unfortunately, and we just had our staff return 2 weeks ago. So there's a bunch of depositions that need to be taken, and before we can even do that, step one is getting all the discovery. We need a discovery master in a plan. We can work with them to get a plan to get these documents produced. I don't want to sit here and ask for sanctions against Mr. Baghdadi because he didn't produce the documents. I just want the documents. That's it.
So a facilitator, a discovery facilitator, can devote not only a whole lot more time to ferreting through your discovery disputes than I'm inclined to do, but what he can also do is negotiate back and forth to try to get you to a resolution, and I can't do that. I see real advantages here, not just for me, avoiding a lot of work. Not that isn't certainly part of my motivation here, gentlemen. Let's be honest.
You're one of the hardest working judges we know.
I think this is a case where facilitation could be very helpful, and who knows? One of the things that facilitator can address is if you need an extension of discovery, how much of an extension, and can work on that issue as well. If you choose to use the facilitator you used previously, it keeps that individual engaged in the case and probably puts him in a better position to broker an overall resolution to the case. But I'm not going to tell you who to use for a facilitator. If I have to pick one, I've got to follow a list. I don't have the ability to go down that list and say, hey, I know this guy's going to do a good job. I cannot do that. When I pick a facilitator, I strictly have to follow our list of people who've been approved as facilitators. I don't think you want me to do that. If ultimately I have to pick one, I will, because you can't agree on one, but you're going to be far better off picking this facilitator. So I am ordering appointment of a discovery facilitator pursuant to MCR 2.411 H. And all discovery issues have to be processed through this facilitator before they be brought back to my attention. And I don't remember who filed the first motion here.
Mr. Baghdadi.
Okay, Mr. Baghdadi, it's your responsibility then to prepare this order and get it submitted.
And we'll talk. We have a good working relationship, so we'll be able to talk and try to work out a mutually agreeable, if not the same, facilitator.
Okay, good luck, gentlemen.
Thank you, Judge.
Happy New Year to